Bill of Rights, the 1960 Bill of Rights, is still a law of this land. I mean, we have a Charter of Rights and Freedoms, which is very important. But the Bill of Rights says very explicitly that Canadians have the right to life, liberty, security of the person, and also the right to enjoyment of property that cannot be deprived except with due process of law. And so if the government, under the Governor and Council, are they bound by the Bill of Rights when they come up with policies to confiscate firearms? Are they bound by the due process of law in the Canadian Bill of Rights when depriving people of the enjoyment of their property?
Sorry, my earphone's not working, but what I can say is that the Supreme Court ruled in, I think it was 1991 or 1992, in the firearms the firearms reference case, that there is no right in Canada to possess firearms.
I don't disagree with you. But in terms of property, if you are given the right to own a firearm as property, firearms are property as well, the government can't just seize that property except through due process of law. Would you say that is correct?
So I think what one of the questions is with respect to the federal criminal power, and the reference re firearms decision by the Supreme Court of Canada determined that firearms and the regulation of firearms falls within the criminal law power versus the provincial power over property. Mm-hmm. And it also indicated that there was no right to firearms in Canada.
But this is the Bill of Rights. This is a federal law, not a provincial law. Are you aware of the Bill of Rights? Is it still in force in Canada? Like, it still has power in this country, the Bill of Rights?
Yes. Yes, it does.
And so what I'm getting at here is that it seems like the government, is trying to, through the buyback program in the May 2020 OIC, trying to respect the Bill of Rights and say, we're going to confiscate your property, which is a violation of the Bill of Rights, but we're going to make it up to you because we're going to compensate you for that property. It happens all the time in this country, eminent domain laws, when people have their property seized to build a highway, the government has to compensate you for that. That's the due process of law. But if the government passes this amendment that we're talking about today, G4, and it's not, is it notwithstanding the Bill of Rights? Because is that something that the government's saying, that this will be notwithstanding the Bill of Rights protections for property rights?
So the criminal law falls under the criminal law power that is under the federal jurisdiction. And that's what I can point to when we speak about criminal law and this legislation that is being amended through the bill and the motions. It is under the federal criminal law power.
Yes, I understand that. I guess what I'm trying to say is that because this will be an act of Parliament and not a regulation, as we've already cleared up, this bill will be on an equal playing field with the Bill of Rights, and therefore will not necessarily be subject to the Bill of Rights protections on property right. And so what I'm submitting, that the reason for another additional reason why the government is submitting this through legislation is not only, as they said, to prevent any future government from repealing these OICs, they would have to repeal it through legislation, but they're doing it to relieve the government of any responsibility to compensate people for their firearms. And that's something, that's something that I think is very worrisome.